In section C, now we're going to take a look at the easement by prescription. And so that is in your book, discussed over on page 516 and following. So let me grab that and share that for you. Here we go. So the authors talk about easements by prescription. It's really analogous in some ways to adverse possession. Adverse possession, we saw how if you use a piece of property long enough, you can acquire title to it. If you are using it in a way that satisfies the requirements for adverse possession, it's adverse to the owner and continuous and open and notorious and all of the requirements that we looked at earlier. And the theory of adverse possession is that the owner has a cause of action to eject somebody who is using their property. But if they don't act quickly enough, the statute of limitations will run and bar the action. And so effectively, that running of the statute of limitations creates a new title in the adverse user. And so prescriptive easements are kind of similar, except that what you're trying to establish is not title to the property, but merely the right to use property. So if you're using someone else's property, you acknowledge it's theirs, but you're using it for access for a long enough period of time, and you satisfy the requirements for a prescriptive easement, then the statute of limitations may run, and you may have an easement created by virtue of the running of the statute of limitations. They tell us that most jurisdictions, it's the same statute of limitations period that you would have for an adverse possession claim. But they also tell us that there are a few jurisdictions that use a different theory to explain prescriptive easements. And there, the idea is that you have been using the land for long enough that the courts are just going to assume fictionally that there was some grant in the past that gave you the right to use it, and that's now been lost. Notice the elements listed in note 1 here on what must be established to demonstrate the existence of a prescriptive easement. Notice that they don't list exclusivity in that list, but they do get to exclusivity over in note 3. And basically what they say is that exclusivity is not required in some jurisdictions, and it makes sense maybe that it isn't, because you're not trying to establish that you own the land, you're simply trying to establish a right to use it along with the true owner. But there are some jurisdictions that require exclusivity but mean something slightly different from it by it than they do in the adverse possession context. And so Page versus Bloom, exclusivity doesn't require showing that only the claimant made use of the way, but that the claimant's right to use the land was not dependent upon a like right in others, so exclusive in a different sense. So on the lost grant theory, if you go back up to note 2, jurisdictions that assume that there must have been some grant, or that pretend to assume that there must have been some grant at some point in the past if you've been using a right-of-way for long enough. The authors tell us that there is a distinction that is drawn between acquiescence and permission. If you have permission of the owner, then you do not get an easement by prescription. But they also say, in jurisdictions following the lost grant theory, that the owner has to acquiesce or not object to your use of the easement, and that if they object, then that defeats the idea that there was some grant in the past. And so they cite a case from a jurisdiction following the lost grant fiction, concluding that a letter to the party using the property can be enough to defeat the easement by defeating any claim of acquiescence. And so they ask at the bottom of the page, would a letter to a possessor stop adverse possession from running? There, the answer is no. A letter won't interrupt adverse possession. Nothing short of making entry or legal action will break the continuity of possession. Now, over at the top of page 517, the authors say that suppose, under the preceding facts, that in 2003, O had erected a fence across the road, and that A tore down the fence and continued to use the road. Does A acquire a prescriptive easement in 2013? And we're in a jurisdiction that is using the adverse possession theory for a prescriptive easement rather than the lost grant theory. And the authors indicate that in a jurisdiction that uses the adverse possession theory to prevent a prescriptive easement from being acquired, the owners must effectively interrupt or stop the adverse use. The restatement of servitudes says to be successful, the owner must either cause the adverse user to stop the use, or comply with a statutory procedure that produces an interruption, or bring a legal action that results in establishing the landowner's right to terminate the use. A physical interference with the use is effective only if it brings about a cessation of use. One wonders if that might be a doctrine that would be calculated to produce conflict between neighbors. That you can imagine all kinds of unhappy situations where one neighbor is trying to physically stop the other from using a roadway, putting things in the roadway, trying to keep them from using it, and the other neighbor isn't having any of it. I wonder if that could be a potentially dangerous situation. Now, take a look at note 4 on page 517. Here we have a person who lives by a golf course, and the golfers keep coming onto the person's property to retrieve their golf balls. And so the question is, assuming that goes on long enough, does the country club acquire a prescriptive easement? Well, they cite a case here, the McDonald Properties case, where the court found an easement for the country club and its members so that they could come onto the property and continue to retrieve their golf balls. So if allowing the golfers to come onto your property to get the golf balls risks the creation of a prescriptive easement, is there anything that the landowner could do to stop the easement from coming into existence? One possibility is put up a fence, just keep the golfers out of your property. Another possibility is maybe you sign an agreement with the golf club that indicates that the use is permissive, that you are allowing golfers to come onto your property and that you can stop doing that at some point in the future. But if it's permissive, then they shouldn't get a prescriptive easement. Or maybe you just need to sue the country club earlier to stop the golfers from coming onto your property. Now, note 5, public prescriptive easements. The authors tell us that many jurisdictions now allow the public to acquire an easement by prescription from long use of a road or other access. And that sometimes this is explained on the theory of implied dedication, that the landowner effectively allowed the public and by granted the public a right, allowing them to use the road. Finally, I want to talk a little bit about note 6 on page 517 and 518. And here we have an issue that comes up in a lot of jurisdictions about access to beaches. That is a topic that has produced litigation in various places. But I want to talk about a particular doctrine that is important in this area called the public trust doctrine. And so on page 518, the authors talk about the public trust doctrine. Let's see if I can find that. where is that? Okay, so under the public doctrine in most states, the public trust doctrine, in most states, the state holds in trust for the public the beach from the water to the mean high tide line, the wet sand. The dry sand portion of the beach between the mean high tide line and the vegetation line is subject to private ownership. And so let me give you a figure to kind of show you what they're talking about. Here we go. So in beachfront property, there's a water line. So this is where the water is at any given point. But the water ebbs and flows. Sometimes it comes higher on the beach and sometimes it's lower on the beach. And so there is often a wet sand area. And that wet sand area goes up to what they're calling the mean high tide mark, right? The average place where the high tide goes on that particular beach. And then above the mean high tide mark, you've got the dry sand that people often like to use for laying out and that kind of thing. And then if you go further up, then eventually you'll find vegetation taking over and it's no longer sand. And so the question is, what is subject to the public trust doctrine? Well, basically the public trust doctrine says that this portion of the beach, the wet sand area below the mean high tide mark, that is not owned by private parties. Instead, it is owned by the government in trust for the public. And so the public has the right to walk along the beach below the mean high tide mark. They are not trespassing on anyone's private property if they do that. So that is a way of giving the public certain rights of access to beaches, but think about the difficulty that you might have depending on the circumstances. Even if you have a right to walk along the wet sand, how do you get to it? There are many places where you might have to get to walk over private property, over the dry sand or the vegetation area to get to the wet sand. And so it can still create problems of access for the public. We'll talk more about this later on. And that is enough for prescriptive easements. We'll get on to our next topic, the scope of easements, in our next lecture.